So the term neurodiverse means that no two people see the world around them in the same way. So we're all neurodiverse, as the term refers to everybody, whether you've got a clinically well-recognised condition or not. Now the term neurodivergent has become to mean a person with brain processing differences, so such as dyslexia, dyspraxia, ADHD, autism or OCD. Well, first of all, 1 in 7 people are thought to be neurodivergent, so the likelihood of an employer employing somebody with a neurodivergent condition is highly likely. The impact is not a negative one, as neurodivergents can thrive in the right environment, and some of the common symptoms of neurodivergent conditions can in fact be a real benefit to an employer. So for example, those with ADHD may have trouble with time management, although they often show tremendous drive when they're interested or passionate about something. They're also very creative, and even one of the principal traits of ADHD, which is impulsivity, can be a benefit in the workplace, because people who are too afraid to say things sometimes don't say things, whereas those with ADHD often will say it. So the impact is certainly not a negative one. In terms of autism, employees with autism can be incredible problem solvers, and one study has suggested that autistic employees were 140% more productive than their neurotypical colleagues, with attention to detail being a real strength. So again, the impact can be a very positive one. Well, the first key consideration is actually knowing about it, so having knowledge of somebody's impairment, because if the employer has no knowledge that the employee is in fact neurodivergent, it can't get the best out of its workforce and it can't make any adjustments that are reasonable. Now, knowledge is broken down into 2 subsections. You can actually know that an employee has a condition, or something called constructive knowledge, which is you ought to have known. Actual knowledge can arise from being told. So, an employee can just disclose this to you, and they don't have to disclose it to you at the start of employment, they can disclose it during employment. Now, constructive knowledge is a bit more tricky, because that's when an employer ought to have known. So the Disability Code states that an employer must do all that they reasonably can be expected to do to find out if a worker has a disability. So this means that appropriate systems should be in place for an employer to ask questions. You must create a safe environment for disclosure, one which maintains dignity and confidentiality at all times. Well, one of the biggest considerations for avoiding discrimination is reasonable adjustments, and this sounds daunting, and even worse, it sounds expensive for employers. But the vast majority of reasonable adjustments actually cost nothing. There was a case last year which involved an autistic employee who worked for an autism charity, which was found to have failed to make a number of reasonable adjustments. Now, in that case, the only adjustment which was deemed to be unreasonable was the one which would have cost the employer some money. The other adjustments were things like giving the employee appropriate notice of meetings, texting her the night before if there was going to be a particular visitor in the office, were all found to be adjustments that the employer could and should have made, because it would have reduced the disadvantage. Now, adjustments can be almost anything arising out of the employment relationship. So they can be things like start times and finish times, rest breaks, right the way through to some formal policies that you may have around managing performance or misconduct, to kind of informal policies around open plan working or hot desking, or even working from home. The adjustment has to be made if it reduces the disadvantage for the employee, unless the employer can demonstrate that it will suffer a disproportionate burden. And what that means is the employer says, well, look, it's too expensive, or it doesn't really work, i.e. it doesn't reduce the employee's disadvantage, or it's difficult, or it's inefficient, or it doesn't fit with our business model, or the culture of our business, or the size of our business. So you don't have to make every adjustment, but you must consider them. Well, besides reasonable adjustments, the biggest consideration is something called discrimination arising from a disability. Now, this means if an employee does something as a consequence of their disability, an employer can only respond to that act in a way which is proportionate. So examples of this arise often in misconduct proceedings and/or performance management processes. So, for example, an employee will say, I did that act because of my insert neurodivergent condition. And an employer can only respond to that to the extent that it's proportionate. And one example of that was a social worker who had an inappropriate relationship with a service user. They said that their lack of boundaries caused by their autism resulted in this bad behaviour. And the Employment Tribunal said, okay, we accept that the two are linked, but the act of dismissal was proportionate in those circumstances. At the other end of the spectrum, if an employee was late on a couple of occasions, which was connected to their neurodivergent condition, it may not be proportionate to dismiss them during their probationary period, whereas it might be for a neurotypical person. I think it would be useful to look at that question in reverse, because there's a legal obligation for an employer to make reasonable adjustments only if an employee is a disabled person within the meaning of the Equality Act. Now, only a tribunal decides that. It's not the employer that determines it, it's not a medical person that determines it. A tribunal determines if an employee is a disabled person. They will only determine that after they review the medical evidence and listen to the witness testimony about the impact of their condition. But without any formal diagnosis, an employee may struggle. But if you look at the definition of disability, you should be asking your workforce, well, and you're not sure yourself, you should be asking your workforce, well, how does this impact your normal day-to-day activities? And that doesn't mean that it needs to impact their normal day-to-day activities at work. It can be things outside of work, things like their sleep, their commute to work, their ability to get out of bed in the morning, difficulties associated with meeting targets and attendance and behaviour. All of these things, if they struggle with them and it's long-lasting, so more than 12 months, then it may be classed as a disability within the Equality Act 2010. Well, there's lots of support out there actually. There's organisations which are specialist organisations that assist with neurodivergent conditions only. For example, Creased Puddle, which is an organisation that works across the UK, working closely with organisations and individuals to enhance understanding and empower decision makers and identify opportunities for inclusion for neurodivergent staff. You can speak to your legal team, you can speak to ACAS. It's very important to have an up-to-date medical opinion, if possible, before you actually determine any adjustments or any sanctions. So liaising with the individual's consultant or GP is really important, and if not, then the employer should consult with occupational health.